All right, Ms. Anguilova, just for the record, obviously I know your name, but can you please state your name for the record?
Reni Petrova Angelova, but no one in America can roll their R's, so rainy like a rainy day.
Wait, I'm sorry. What did you just
Reni
say?
Petrova Angelova is my legal name. It's Bulgarian. I am a citizen of that country. I, however, grew up in Eagle County. My name's Reni,
Okay.
Rainy, Rini, however you want to call it. It's Reni, but technically you're supposed to roll the R's, but most Americans can't. No
Gotcha.
disrespect.
Okay. Ms. Angelova, did you have a chance to watch a video that advised you of your rights?
Yes. Do I even have any rights as a non-citizen of this country?
Well, you should have also received an immigration advisement as well. Do you have any questions about those rights that were set forth within that video?
Yeah, but I think I'm going to reserve those questions for my lawyer. And
Okay.
I
Okay, that
honestly,
sounds just fine.
just, since we're on the record, I will take accountability for my mistakes, but I refuse to take responsibility for things that.
You should probably not make any statements until you've had a chance to talk to me, okay?
Yes, sir. You're one of the few lawyers I respect. You actually have a good heart. Unlike. Oh.
Okay.
I'm sorry, I haven't slept in months. Given everything that has transpired in the last 2 weeks, holy Toledo. And talk
All
about,
right,
it's one thing to have your nursing license revoked when you were trying to fight to keep it, but as a former medical professional, Eagle County couldn't help me with my.
Hey, Ms. Anguilova, you need to take a breath, okay? And I want you to just listen first.
Yes.
And then we'll determine how to proceed in your case. What I'm doing now, I'm going to advise you of the charges against you. And then we're going to set your bond so that you know what you need to post, if anything, to get out of jail. Okay? So just take a moment, and we're gonna need you to kind of listen for a little bit.
I'm listening. I'm shutting up and I'm listening.
It's okay.
I'm
All right.
sorry,
So I
gonna
understand.
pace a little
I
bit, helps with
understand.
my anxiety, because God forbid you ask for Xanax
I
when
know.
you need one.
I know. Okay.
Breathing.
All
Lay it
right.
on me.
Hold on. You are charged, in this case, you are charged with 1 count of aggravated motor vehicle theft.
Okay, that's bullshit.
And
Okay.
let me just take a look at, hold on.
Everybody wonders why people drink themselves to death or kill themselves. It's because we're not getting the help that we need. Where was Eagle County?
You're actually charged with motor. I need you to listen. Okay. So motor vehicle theft in the 3rd degree is a class 5 felony. It carries with it potential penalties of the following. Hold on. It carries with it the following potential penalties. How did I put that? Here we go. 1 to 3 years incarceration, $1,000 to $100,000 fine, and 2 years mandatory parole. You're charged with evading an ignition interlock device. Let me just take a look.
Might as well just put a fucking gun and shoot me. Shit. It's okay. I've survived this long. There's a reason why I'm still alive, and despite
Ms. Anguilova, I'm going to mute you right now because you're making all sorts of statements, and I don't want you to make any statements right now, okay? All right, so evading an interlock device. This is a class 2 traffic misdemeanor. It carries with it potential penalties of 10 to 90 days in jail and or up to a $300 fine. You're charged with failure to yield to an emergency vehicle. That is a class 1 traffic misdemeanor. It carries with it potential penalties of 10 days to a year in jail and or up to $1,000 fine. or maybe points against your driving privileges. You're also cited for domestic violence. That includes with it additional penalties, included but not limited to the requirement that you complete a domestic violence evaluation and follow all of those recommendations. Mr. McMullen, are you appearing on behalf of Ms. Angelova for the purposes of bond today?
I am, and I do waive further advisement.
Thank you. Would the people like to make an argument for bond?
Yes, Your Honor. The people would be asking for a pretty elevated cash surety bond of $7,500 cash surety. The people have some serious public safety concerns here. The defendant has a 2024 probation complaint for a DUI case. The prosecution had filed a motion to revoke her probation on 2/26. This was after she left competency court. She was restored. She hadn't been testing for drugs and alcohol from that. She picked up in 25T59, she picked up another DUI charge that was on January 19th of 2025. There had been a conversation at the last court date that the defendant was supposed to be testing through GEO, and she was supposed to be testing through probation. We didn't see anything filed in the GEO in her GEO report that she had been ordered. She had been ordered by you on 4/14, last court date, to go to GEO for random testing that day. We called GEO this morning to confirm that she has not started testing for GEO since then. And her case with GEO has been closed since late 2024 because she has never been testing. That's a concern as she's picked up her DUI. Was on a DUI charge then. She's picked up that DUI charge in early 2025. She, since, as she alluded to, she's had 18 law enforcement contacts in the last 2 weeks, and intoxicated on several occasions, when she's been in touch with law enforcement, specifically on April 29th. She was in touch with Vail Police Department. She was contacted. She was trespassed from 10 Mountain Whiskey. We have a summons forthcoming from that case. She was also trespassed from the George. They did not summons her on that case. Both were alcohol related. Following those trespass, she was contacted from Eagle PD, was contacted her on the 23rd for an assault charge. Also on the 23rd, she was charged with disorderly conduct and resisting arrest, as well as this motor vehicle theft case, the current case that she's being held for. A concern that we have here is that in the CAD notes and on the call, when the victim reported his car being taken, he said that it was because she took his car because she couldn't use her car because she had interlock. So she would not be able to start her car. There was nothing mentioned explicitly about drinking in the affidavit. However, the people have concerns that she was intoxicated at this point when she was arrested because of her comments about not being able to drive her car, which has interlock. The people will be looking to determine if there is a driving, a DUI charge is appropriate here. But due to that, we just have serious concerns that she continues to drink, and she's putting herself and other people in the community at risk by doing that. This was also a DV underlying nature charge. So in addition to the elevated cash surety bond and the testing, we'd also be asking for the Title 18 protection order, no contact, to go into place here.
All right. Is Mr. Gardner present? If you are and you want to speak, you need to press *6 to unmute yourself. Okay, Mr. McMullen?
I am present.
Oh, Mr. Gardner, do you wish to make any statements, sir?
Yeah, I mean, I never really, all I wanted back was my vehicle. I didn't think she was drinking. I just, I know she just wanted to use my vehicle and never really asked me, that's all.
Okay. Mr. McMullen?
Thank you, Your Honor. I think based on Mr. Mr. Gardner's statements, as well as the fact that I think we're all familiar with Rennie. She's been around a while. She comes to her court dates. She's demonstrated responsibility. She's been a caretaker for elders. She is getting set up with some help with a church in Avon that's been helping her relocate. She's supposed to start a new job in the coming few days, but the church in Avon is going to give her some help getting a residence. She's also currently going through an eviction, and because she's in custody, has not been able to pick up her stuff. She's not sure what's going to happen to her stuff. If she gets out of custody, she'll be able to organize her relocation with the church so she can get it set up with a place to stay. I would ask the court to consider a personal recognizance bond here. I know there's some allegations in the new case about potential new charges, but it seems that based on the four corners as well as what Mr. Gardner is saying, it doesn't sound like that's the case. And it sounds like he would like a personal recognizance bond as well, if I'm interpreting what he's saying correctly. And as the victim of this case, seems that his car was returned to him without issue. So we would make that request. Really, any amount of bond would keep her in custody. So at the very least, an elevated bond is not necessary.
Okay. All right. I understand what Mr. Gardner has just stated on the record now. I also understand that that's the opposite of what he told law enforcement. And that all being said, I do have concerns, community safety concerns. There's always concern when there's still substance abuse and still driving. I cannot ignore that that poses a significant, substantial risk to our community members. And until we get this under control with substance treatment, I also think we need to try to identify some mental health treatment as well. Until we can wrap our arms around that, I'm going to set bond in the amount of $2,500 cash or surety with the following additional terms and conditions. And then we'll talk about what all that looks like in a minute. You're to sign a waiver of extradition. You are to remain law abiding. You are to report to GEO reentry services within 24 hours of your release to be tested for drugs and alcohol at a frequency not to exceed 10 times per month. You are not to consume or possess alcohol, drugs, or recreational marijuana. You shall not drive during any period of restraint. You must obtain court permission to leave the state of Colorado, and you must notify the court within 24 hours of a change of address. Additionally, a protection order shall issue. The terms of your protection order are as follows. These are also conditions of your bond. You are to have no contact with Garrett Gardner. You are to maintain a minimum of 100 yards distance from him. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You shall vacate the home of the victim and stay away from any other location he's likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim in this case. You shall not possess, purchase, or control a firearm or other weapon. You shall not possess or purchase any ammunition, and you shall relinquish all firearms within 24 hours of your release. Additionally, you shall not possess or consume alcoholic beverages or controlled substances. I will authorize a civil standby. That is a legal mechanism that allows you to utilize the services of law enforcement one time to go back to the residence if you mutually share a residence to obtain any items of personal belongings you might need while this protection order is in effect. Because you are being charged with a crime that is alleged to be an act of domestic violence, it is a condition of your bond and a condition of the protection order that you neither possess nor receive any firearms or ammunition during the period of your protection order. As indicated previously, if you have firearms or ammunition, you are required to relinquish those within 24 hours of your release. I will send a firearm affidavit to the jail. That is a document wherein you declare whether you have firearms or ammunition. You need to complete that before you are released. Your failure to timely complete that affidavit or to timely relinquish your firearms or ammunition could result in additional charges being filed against you, could result in your release on bond being revoked, or could result in you being found in contempt. Ms. Anguilova, it's your responsibility to try to listen. I would hope that you're listening. Lastly, you need to appear at your next court appearance and all future court appearances. Mr. McMullen, I have court appearances all over with the amount of new cases that she has. She has arraignments set on a whole bunch of different days because they're set based upon the date of the ticket. She's next set with you on June 9th at 9 a.m. Do you want me to set it on that date, or what do you want me to do? You need to unmute yourself.
Yeah, we can set it there for now. Any subsequent appearance before that date, just I'll assume she's not posting a bond and that every case will be open to the public defender.
And Mr. McMullen, if Bridges, like, hopefully the idea is to have Bridges help connect her with maybe some inpatient treatment. If there's a possibility for her to go into inpatient, then I would be inclined to modify her bond to a PR bond for the purposes of that treatment. But obviously she'd have to be willing to do that, and you can discuss that with her separately.
Your Honor, Beth Bardnelli with probation. Can I just let the court know that she has been, hey Rennie, she has been told that inpatient treatment is the recommendation and she completely refuses. Maybe this may help, but she's been giving all of those opportunities and has flat out refused. So I just want to let the court know that has continued to be attempted by probation.
Well, you know, that's the idea here. There's going to be no conversion to a PR bond unless it's for inpatient treatment. So, now Ms. Anguilova, I'm going to unmute you to see if you have any questions. I've unmuted you. Now is your time to tell me what you want to tell me and to ask any questions that you like.
Oh, where do I start? I'm sorry, when was that date scheduled?
Sure, it's June 9th, 2026 at 9 a.m. You have other court dates before that, all through the month of May. You have court dates in your other cases.
So when is the soonest you want me to appear to the court?
Let's see, I think your next earliest court date, let's see, we have, not that one. You have May 13th at 9:30 a.m.
Okay, that's good. May 12th, I have an OBGYN appointment in Valley View. Hopefully I'll get the right medication this time.
May 13th at 9:30 a.m. And I think
for the
that's
record,
your
I
earliest
don't want to drink, Your Honor. I don't. You watch me drop it just like that. I have a genetic kidney condition that's going to take my life early. I'll be lucky if I make it to 45.
Ms.
I couldn't get the
Anguilova,
right health care 4 years ago when I asked, and I resorted to alcohol the last 4 years.
and now's your chance. Now's your chance. So it's on you to try to work to utilize the Bridges liaison to help locate inpatient treatment, okay? That's mental health and substance abuse. That is,
Yeah, does all poison
it
take
should be a
Medicaid?
positive. That should be a
Okay.
positive for you,
I
okay?
just okay, and since we're on the record, there's a documentary that I think every medical and professional take care of Maya. I feel like that nurse in that movie. I want to
Okay,
live
good,
the
'cause
last time
I
that
just
I'm
want,
left on this
Ms.
planet before I
Angelova,
get really sick in peace.
Ms. Angelova, all I want for you is to get help. That's all. You
Okay,
know
but
that you
we
need
get
it.
out so I can do what I need to do to do the things. Please.
I know you need to address these issues, and the
Been
way that you can
trying
do
to.
it, I know. All right.
It's hard to do it when you're alone and you're a single immigrant woman in this county. Who I honestly, like, I'm a smart woman, but man, my choice in men, holy shit. I could be making over 100 grand right now working at the state-of-the-art dialysis center.
Court's going to call case number 23 CR 884, People versus Michaela Mayberry. I'll take entries starting with the people.
Amanda Becker for the people.
And good morning, Miss Mayberry. If you can just state your name for the record.
Oh, Your Honor, I respectfully appear by special limited appearance as the living woman, Michaela Mayberry.
Okay. This matter was set for a jury trial back in February, and Miss Mayberry failed to appear. We need to get this reset for trial. And how many days were we setting this for?
It was set for 5 days. Your Honor, the people do have a motion for non-testimonial ID that is pending, as well as a motion for added counts that would qualify for PH.
Ms. Mayberry, did you wish to make any record on the motion for non-testimonial identification and the motion to add counts?
Your Honor, can I make a few records on a statement before we proceed
Go
with
ahead.
any other actions?
Go ahead.
Okay. As mentioned, I respectfully appear by special limited appearance as the living woman, Michaela Mayberry. I must first place a few matters on the record before any other actions proceed, as these are fundamental to my understanding and peace of mind, and I speak them in good faith and honor.
Okay, go ahead.
Okay. I'm here today propria persona, not pro se, not as a defendant, not as surety. I am not representing a legal fiction, and I do not voluntarily submit to any roles presumed upon me under any administrative titles or statutes. I reserve all of my rights without prejudice under UCC 1-308 and demand that none be waived knowingly or unknowingly, as I do not consent to any contracts or jurisdictions not fully disclosed and agreed upon. Notice was already served, including IRS Forms 2848 and 56, formally revoking any presumed power of attorney and relationships that may have been assumed by this court or its officers. And in doing so, I did send notice via certified mail to the courts and its officers, including the DA, and with the recipient's acknowledgement with the green return signature slips that I received to my Texas abode, chose acquiescence with no rebuttal to any of the notarized claims or notices that were sent. And to my surprise, there was like some unsettling financial documents that I discovered. And in law, acquiescence is considered, acknowledgement, and they had the duty to respond and chose silence and didn't rebuttal.
Okay.
So the acknowledgements and agreement was agreed upon per the UCC 1-202 notice acknowledgement and mentioned in CFR, like 11 CFR 111.45 in the administrative procedures.
Okay.
And the financial documents that were discovered were obtained by my financial institution, Fidelity, which were verified by Bloomberg specialists. in the matter 23 CR 884, to my surprise, developed a CUSIP number 316138106 with the fund symbol FEQIX, pretty much terrifyingly saying that this is proving that this court has a financial interest in the matter. And it also proves that this is not government, but a corporate entity. So, Your Honor, how can I ever be tried fairly and just if the court, when the court and its officers hold a multi-million-dollar financial interest in the matter, and it's being traded through the CRIS system and on the stock exchange as a security?
Okay. Ms. Mayberry, did you have any position on the motions that were filed?
Yes, these are my positions. Leviticus chapter 19, verse 15 states, there should be no injustice in the court. So where is the justice? How is this justice? So I'm not consenting to gender with any corporate entity bearing my name in all capital letters, as I respectfully stand on all of my rights and do not consent to be administered. I'm not here to disrupt. I'm not here to argue. I'm simply here to preserve the record, speak my truth in peace, and request that no adverse inferences be drawn from my silence or non-participation in assumed procedure.
Okay.
And I request that if this court intends to proceed, that it produce on the record today a verified claim by a living injured party, the DA's license to practice law, and not their bar membership number, a lawful contract bearing my signature, and a proper delegation of authority granting this court jurisdiction over me, the living woman.
Okay.
And if this court does not possess any of those items or all of those items today, that I ask that this matter is closed and settled honorably, as I do not consent to coercion, incarceration, or any compelled contracts. And again, respectfully request that no adverse inferences be drawn from my silence or non-participation in assumed procedure.
Okay.
May God be with me as He, the Most High, is the only one who can judge me. 1 Corinthians chapter 4, verse 4 and 5 state that it is God who judges me. Therefore, do not pronounce judgment before the time God comes, who will then shed light to the things now hidden in the darkness and disclose the true purposes of the hearts. And then each one will receive their commendation from God.
Okay.
And I thank this court for honoring my peaceable notice and appearances.
All right.
Praise be.
Thank you, Ms. Mayberry. What the court's going to do, the court's reviewed the motion to add counts. Court's going to grant that motion. I know Ms. Mayberry's record that she made today in regards to each of those motions. Ms. Mayberry has previously been advised as to her right to court-appointed counsel. Ms. Mayberry has previously represented that she intends on representing herself. Court's also going to grant the people's motion for non-testimonial identification. Based on the added counts, court's going to set this for a preliminary hearing. How much time do you need, Ms. Becker?
For the preliminary hearing, I would ask for 2 weeks to make sure that subpoenas are received.
And how much time for the actual hearing? An hour?
An hour.
Okay. We're going to set for a preliminary hearing, and then we're going to clear, did you say 4 days for trial?
Yes, Your Honor.
Okay.
Your Honor, so sorry, before we finish, so the people, since Ms. Mayberry is pro se, will have the detective in this case go to the jail with his body worn camera, and he will do those buccal swabs at the jail under video.
Understood.
Your Honor, I'm not pro se, I'm propria persona. And I asked the court if they had any of those documentations today.
I'm respectfully denying the request that they produce those documents today. You've made your record, but I'm not going to grant that request. All right.
So is this court not dealing justly?
I'll let everyone make their record, Miss Mayberry. We'll see you at the next court date. We'll be in recess.